Welcome to the Financial Purpose Podcast. All opinions expressed by me or guests of the podcast are solely our own opinions and do not reflect the opinion of Life Moves Wealth Management. This podcast is for informational purposes only and should not be relied upon for any financial or investment decisions. Clients of Life Moves Wealth Management may maintain positions in the securities discussed in this podcast. Hello, I'm your host, Dale Schaefer, and here's another great episode starting now.
Let's go.
Welcome to today's show. It's the Financial Purpose Podcast, episode 38. Today is Monday, April 8th. That is Eclipse Day. The eclipse is actively happening as I record this. And because I am a total nerd, I did not go buy eclipse glasses from anywhere. Instead, I made a homemade eclipse viewer with two paper plates and a piece of tinfoil, and you poke a hole in the tinfoil, and then you can hold your paper plates however wide apart you want, and you can actually track how the eclipse is moving. And total nerd stuff, total like third grade science. But you know what? I stood outside with it. It was super cool. Melissa thought it was pretty cool. She probably thought it was super nerdy, but whatever. It worked. And right now, since it's kind of getting a little bit darker outside, and I'm assuming that if you're listening to this, then it means that for the most part we survived. Aliens didn't come down and start a war, or we didn't start a war, or the power grid didn't go into complete failure, and electric cars didn't just totally stop in the middle of the freeway and cause massive, casualty accidents or things like that. Or what are some of the other? The government didn't use it as a way to enact martial law to keep us all, trapped in our homes while they do whatever takeover they were going to do. I don't know. I've seen, Jesus didn't return. Maybe, I don't know. I've seen all sorts of crazy conspiracies, everything from, flat earth stuff to religious stuff to the path of the path of the eclipse crossing through these specific named towns. And so that means X, Y, and Z, whatever. If you're listening to this, we made it. Let's have a party. But that leads me to the point of the topic of this particular episode, which is one that's been kind of heavy on my heart for a few weeks, for a lot of reasons. March in our family was really a weird month. We in the month of March, we had a family member pass away that had been ill for a while, and the disease got progressively worse, and then very quickly she passed. And then on the exact same day, we had to put down our family dog, who his name is Jasper. Some of you listening may have met Jasper, especially clients or friends of ours. He'd been in our family for a long time. We got him in 2010. He was, a few months old when we got him, and he was a stray rescued from a dog park. And we think he had been abused or whatever, but we took really good care of him, and he was a part of our family for a long time. So Jasper went down, and the day before those two things happened, Melissa and I celebrated our 14th wedding anniversary, and then a week after that, I celebrated a birthday. But a couple of weeks before that, we lost a very, very close and dear friend of ours in a tragic car accident, and that weighed really, really heavily on the month. And it kind of, it was a stark reminder, not to bring down the mood too much, but it really was a stark reminder of the need for both myself and for what I do for clients to just put a little bit of a better focus on something that we don't really like to talk about very often, but is very important. And that really is what happens at the end of our lives, and how do we prepare for it beforehand, and what can we do along the way. So when I'm kind of going through the process, when somebody passes away, there's a checklist that I take clients through, and it's 4-ish page checklist. It generally takes on purpose about 6 to 9 months or maybe a little bit longer to complete. And I say on purpose, it's because it just involves a lot of changes. And each one of those changes brings on kind of a new form of finality of the situation. And so I like to kind of, some things we do very quickly, some things we just take our times with, based on where we are in the stages of grief and what. But for this episode, I want to simplify all of that. I want to back up the bus just a little bit because that checklist starts when somebody passes away. So I want to give you a couple of things to consider before that happens. I'm going to bust a couple of myths about death and what happens financially along the way. But this episode is intended to just give you a couple of quick things that you either need to work on or that you need to just check on to make sure that everything's in place. So get your pen, get your paper ready. Since it's Eclipse Day and it's going to get a little bit darker, I have my bat pencil that I'm using to take notes. It has little bats on it. So again, grab whatever you want. If maybe you're grabbing your Remarkable tablet, which I just started using a couple weeks ago, and I want to thank my good friend Lauren for turning me on to that because it's been a total lifesaver, life changer in the way that I run my meetings and take notes and things like that. So, however you're going to take notes, do it because this is an all skate. It's an episode that everyone can take something from. So before I get into busting myths and giving them maybe the top 5 things to take care of, let me talk just a little bit about some sensitivity around end of life planning, some emotional concerns around end of life planning. Culturally, this conversation can be held a number of different ways based on your religion, your customs, your ancestry, your traditions, things like that. People have different traditions around what happens when somebody passes away, and certainly traditions around talking about how to prepare for that. And so it's often an emotional subject. As I said earlier, nobody wants to deal with their own mortality. It can talking about end of life can simply it can invoke a lot of fear or anxiety, or some sadness. It can bring back memories of somebody that you lost, and it can trigger all sorts of things. There's family dynamics to consider, as far as priority of who's involved at what level and in what order and things like that. Um, there are all sorts of you know not only legal documents and things to consider, but the way that those are written. There are some, like I said, cultural um, order of events that need to happen. And so, whatever that is for you, I just want this to be again a conversation that's more helpful than it is anything else. And it's important just to acknowledge that this can be a very heavy subject. So I'm going to try to lighten it up a little bit and give you some things to take away with in a decent amount of time. So let's get started first by getting rid of a couple of assumptions or busting a couple of myths. These are things that people tend to think about the process of end of life planning or estate planning, even. And some of these myths really do need to be busted. So, first and foremost, the very first myth that I want to bust straight away and quickly is that there's a myth that only the wealthy need estate planning. And that's just entirely not true because anybody who owns anything whatsoever needs some form of estate planning. In a lot of states, even if you're like listening to this and you're like, well, I don't have a lot of stuff, I don't own property, I don't have retirement accounts, I don't have a lot of money in the bank, that kind of thing, that's fine. In your state, in most states, there is what's called small estate affidavits. And I would invite you to just Google that for your particular state and get a handle on exactly what would need to happen. Most of the time, it's very simply I own a car and a couple of bank accounts and some jewelry and things like that. I want these things to go here, 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 and here. And in the smallest state, as long as you meet the requirements, oftentimes that can bypass probate, and that can become very important. But if you own a house and cars and retirement accounts and life insurance policies and bank accounts and other personal property, you're going to want to do some kind of estate planning. And even if you think your stuff is not worth that much, you really ought to think about that and evaluate really what you own and how you want that to be disposed of, because you want to make sure that the things that you've worked your life to accumulate go to the people that matter most to you. You don't want that to get tied up in court. You don't want it to be contested by estranged family members. And you most certainly want to be clear about it, because the second myth is that the myth that your family will know what you want. And that's absolutely a myth unless you completely say, this is what I want to have happen for me. This is how I want these decisions to be made. And this is where my stuff needs to go. That needs to be written down. And it's best written down in the form of a legal document. The third myth is that a will, the document will, is only about distributing your assets. And the thing about a will is that if you only have a will, it can do a lot more than dictate the distribution of assets. It can control things like who takes care as guardians of your minor children. It can express your final wishes, your funeral wishes. You can also write in your will or attach to your will personal statements to loved ones. So that document is not something, and this is myth number 3, part A, because it's not really written down, but I just thought of it. A will is such an important legal document that you really don't want to just download a sample template from the internet or from LegalZoom or something like that and just assume that your situation applies to the template. There are clauses and language and words in there that need to be carefully thought through and written specific to your situation and specific to your wishes. So please be a little more thoughtful about what gets expressed and how that document is written. Okay, will number 4. I don't need to worry about this until I'm older. Well, I don't know how long I'm going to live. You don't know how long you're going to live. None of us do. That's just the real harsh reality. And so waiting until you're older, that day may never come. And I can tell you multiple stories of waiting, and the day never arrives. So it's not something that you're going to want to put off. Life is incredibly unpredictable. Don't wait until you're older, whatever that means. Start planning for having this done, your estate planning process. Start planning to have it done sooner rather than later, and give yourself a timeline. So, I have clients through the financial planning process, and we say, yep, we need to write our estate plan. And I say, great, let's put in here that our goal is to have it written. We've met with the attorney. We've signed the documents. We've finalized the drafts by the end of the second quarter, 2024. Give yourself an actual time frame. And you're going to want to understand, and I'm going to get to this. Actually, this is a perfect segue for myth 5. What I was going to say is you're going to want to understand the cost, which myth 5, end of life planning, is too expensive. And that's also not true. For many attorneys, if you're doing a small estate or a simple will, you can get that done generally within a few $100s, maybe $1,000 or so. If you're going to couple in a trust and a HIPAA authorization and powers of attorney for your financial and your healthcare needs, and a healthcare directive, that total package, depending on where you are in the country, that probably will cost you somewhere in the neighborhood of maybe $1,500 to $1,800, all the way up to maybe $3,500 or so. And if you have very complex needs, you can see that number move north into the $4,000, $5,000, $6,000, $10,000 range, depending on what's going on for you. But for most people, your window of cost is probably somewhere in the neighborhood of about $1,800 to $2,500. And that sounds like a lot of money, but believe me, for this, it is not, because if you start to calculate what your probate expenses are going to be for your estate, and then God forbid that you have creditors or estranged family members contest or attached to your estate, um, it's going to cost your family more to go through the probate process than it will for you to do this planning in place. So it's really not that expensive. It's a great investment to make in your family and in your future. And it's just simply not something to look at as being too expensive. In some attorneys, maybe there's a way for you to work out some sort of a payment plan, or if you're good at kind of doing your own envelope system, you can save this money over time and then go in and have it done. All right. And that leads me to myth number 6. Once I write my will, I can forget about it. Bad planning. As a financial planner, because I do um, comprehensive planning, we talk about estate planning. I'm going to know when something in your life changes and we need to have your estate documents updated. But also, just as a general rule, you're going to want to have your documents reviewed. You need to review them, maybe review them with your financial professional every at least 3 to 5 years, because I'm going to tell you, Melissa and I wrote our original estate planning documents in 2018. We just had ours rewritten last year, and we already had to make several changes. We had to change out roles and names of people who were in certain roles and remove them and add other ones. So this is going to be important for you to take a look at every couple of years, because people pass away, people are born, um, you know, people maybe get to a point where they're no longer willing or able to serve as your representatives or trustees in a successor role, or maybe you change and those are people that you don't want anymore in those positions. You cannot set and forget this stuff. This needs to be reviewed on a constant basis because your life is always going to move around. And myth 7 is that your debts die with you. And it's important to note that your debts simply do not vanish. Um, they can become responsibility of the estate. It is at the discretion of the debtors. You can do some things with your, say, your auto loans that can have those paid off with an insurance policy if something happens to you before the loan is paid in full. Sometimes small credit card balances can be released. Sometimes certain student loans at the federal level can be forgiven. These are all things that it's going to be, as I said, creditor by creditor type situation. But it's important to note that number one, they don't just go away and disappear. And number two, they don't become the responsibility personally of your children or your spouse, depending on how those debts are titled. So this really, again, comes down to how the debt is held, what the debt is secured by, or if it's unsecured, how much debt we're talking about, and what those creditors are willing to negotiate with your estate. But that's exactly the point. It becomes a negotiation. And if there's no money in your estate, meaning you don't have the assets, then your creditors will have to take losses on those and they'll recover if they can recover anything at all. If there's nothing left to recover, then that is what it is. But they don't just simply vanish. It is something that your loved ones will have to deal with. They will have to make those phone calls. They will have to write the letters. They will have to send copies of the death certificate. They will have to do a bunch of paperwork, and you want to be sure that you don't leave them with a total mess to clean up. Have all that stuff in order. Have it all written down somewhere. If you work with a financial planner, this should all be recorded in your financial planning profile. And so just make sure that it's clean, that it can be cleaned up easily, and that everybody knows what's what. Most importantly, as much as you can, keep your debts in order, pay down debts. This becomes a little more complicated when there's a business involved, and that is a topic for um, another podcast episode. There is a blog post at lifemoveswealth.com on what happens to your business when you die, so please go read that. And that's going to lead me now to the final myth, which is myth number 8, that a power of attorney or a POA remains active after somebody dies. What I typically will hear in this situation is somebody will say, "Oh, I'm mom's POA, and I had that in place before she passed away, so because I'm still her POA, I can sign these documents. Okay. It's a common belief that a POA, which simply grants someone the authority to handle your affairs on your behalf if you can't, sign legal documents, write checks, clear bank statements, things like that, pay bills, whatever. The belief is that it continues to hold power after the grantor, which is the person who gave that power, dies. What you need to know is that at death, that POA dies with the person who passes away. It is no longer valid after somebody is gone. Why? Because the grantor is gone. They can't revoke that power. They can no longer give that power. That power of attorney is no longer in effect because that person is no longer here. So instead of trying to hold a POA or thinking that you hold a POA, simply whoever holds the POA generally is going to be an executor or personal representative of the estate through the will, or they might be the successor trustee. And that's how you have powers to do things on behalf of the person or the decedent or the deceased or your loved one who passed away. It's through either the executor powers or the successor trustee. That's how you're going to do it. And again, the POA is crucial to have on file while you're still alive, because if you are incapacitated or in surgery or some other way unable to serve your own interest, if you get dementia, if you have a memory care episode, whatever it is, if you're out of the country, a POA can be very helpful to continue your estate while you're still living. But after you're no longer here, your executor and or your trustee takes over, and those are the powers that they have. Okay, so those are the myths that are busted. I hope that those were helpful to you. Now let's get to the meat and the potatoes, which is the 5 things that I think these are just practical tips that you're going to want to do. Consider this your checklist of things to make sure that you're updated, that you have on file. If you don't have them on file, get them in place. So the very first thing I've talked about already in this episode is your will and estate planning. I've gone through the documents that typically you're going to want to have in place. But again, if you're writing these down very simply, for many people who have assets that are greater than your state's small estate minimum. So again, Google your state's whatever it is. So if you're in Arizona small estate, or Florida small estate, or Mississippi small estate, whatever state you're in, Google that. Know what that minimum or maximum, if you want to look at it that way, is, because if you're below that, then there are steps that you can take, and this typically your state's court or your county court will give you the steps to take and the documents that you need to fill out to avoid probate. But if you are above that small estate, then you need to have a trust, ideally, especially if you own a home. It can be very helpful. A trust, and then a will. We want the will to be a pour over into the trust, which means that the assets that you own are controlled either by the trust or by a named beneficiary. And typically that's going to be on something like a retirement account or a life insurance policy. Ideally, for most people, those go to other people rather than to entities or to your trust. Your specific needs, we can definitely talk about those, but we want the will to control the least amount of assets as possible, because we want the trust to be very specific in language about how your assets would be distributed and to whom and into what order and in what amounts. So will and trust, we want a HIPAA authorization form that names very specific people that can be standing. For most people, your doctor already has a standing HIPAA on file that you filled out. It tells them who they can disclose your information to. This is a document in case theirs isn't on file, or if you're in another part of the country and you have to go to the emergency room, that HIPAA authorization form can be sent to that hospital to authorize your loved ones who are named in that document to have access to your medical situation and be able to get information, answer questions, ask questions about your well-being, that kind of thing. Then we want to have powers of attorney that are for financial and healthcare. This is typically, in a lot of cases, going to be a spouse or a sibling. In some cases, it's going to be somebody else, but sometimes it is not a spouse or a sibling. Maybe it's a child or a parent that you're giving this authorization to, but they would be able to sign financial documents as needed, or pay bills, or write checks or make deposits, things like that. Or they can authorize certain medical procedures in the event that you're unable to. So a healthcare and a financial power of attorney, those are going to be next. And then finally, we have a healthcare directive, which just gives very specific end-of-life care as you've already wanted it to be done. You've already disclosed and thought through that and had it written in a legal document. And this is helpful because it specifically spells out what you want done. So that way you're not placing the burden at the time or at the moment of truth on somebody who's not expecting to make that decision on your behalf. So it's the old, who's going to pull the plug thing. This document takes care of that. So one more time, the 5 documents that we want to have in place: we have a trust, we have a will, we have a healthcare power of attorney, we have a financial power of attorney, we have a HIPAA authorization, and I said 5, but it's actually 6 because we have a healthcare directive after that. So that's the estate planning. Those are the 6 documents that you want to have in place. If you're not sure where to start, if you want a referral to an attorney in your area, if you want me to attend a meeting with you to get these done, please send an email to info@lifemoveswealth.com and just say estate planning process in the subject, and then give me some insight into how I can be helpful to you. Okay. Second thing that you want to have done in your checklist is your beneficiary designations. Now, this is on typically retirement accounts. You want to name specific people to be your beneficiaries and in the appropriate percentages. Now, you're going to have your primary beneficiaries and you're going to have your contingent beneficiaries. For most people who are married with children, your primary is your spouse, your contingent is your children. Or your primary can be your spouse, your contingent can be your trust, or your primary is your trust and there are no contingents. There's a lot of different setups, but that's typically going to be where you're going to see them as retirement accounts. The second place that you're going to want to have them for sure is in life insurance, and this becomes very important. You want to make sure that your life insurance beneficiaries are up to date, because there are bad stories where the wrong people, and usually it's the wrong people in the case of a divorce and then a remarriage, either get the money or get disinherited accidentally. And so you want to be sure that your beneficiaries are up to date. Bank accounts, it's helpful to have a beneficiary on your bank account, because in the event that you pass away, that bank account will get frozen if there's no beneficiary or no payable on death, designee, or no trust ownership, something like that. So you want to be sure that your bank accounts, you have a clear pathway for what happens to your money in the event that you pass away, so the account doesn't get frozen. If the account is frozen, it takes orders from the probate court to release those funds to whoever the probate court has agreed to release them to. So make sure your beneficiaries in all of those places: life insurance, retirement accounts, bank accounts, any other financial account, brokerage accounts, Robinhood accounts, things like that. Make sure those beneficiaries are in place and that they're up to date. Step 3 is the end of life documents. We've already talked about those in step 1, which is all of your estate planning documents. But basically, it's your POAs, your healthcare directive, and then it's also really helpful to be very clear about what you want for yourself. Meaning, do you want an end of life celebration? Do you want that to be a party? Do you want people to wear Hawaiian shirts? Do you want them to all have cigars? Do you want certain songs played? Do you want certain people to speak? Do you want to be buried? Do you want to be cremated? Where do you want your ashes to go? Where do you want to be buried? Next to whom? What kind of tombstone? Like all of these things. It's helpful to your family if you make kind of a wish list and staple it to your documents and just say, this is how I want to be celebrated. This is how I want to be remembered. Or you can simply say, do nothing, burn me, and throw me somewhere else. Like I've seen those. They're not nice for your family members. So think about this, document it, talk about it with your family. This is a healthy conversation to have. And that leads me to number 4, which is your funeral and burial arrangements. We're just stepping all over these here. This is where you want to pre-plan for that. What kind of services do you want? How do you want that to be done? It's very helpful to have this conversation. It's very healthy to have this conversation. So that way there's no confusion. Um, the passing of somebody who is very loved is stressful. It's hard to navigate. You're in a weird place for those first couple of weeks, which is when all these arrangements need to be made and executed. And so hurt people often aren't able to process where they are and what's going on logically. And so you don't want a disagreement amongst your family members about how you should be cared for and what your final wishes carried out should look like. So document that, have the conversation. The 5th thing here is something that we may not think about, but it's something I've thought about a lot over the past couple of weeks, is your digital legacy. And it's very simple things like, does my spouse or my kids or whoever my next of kin is, do they know how to get into my computer? Do they know where my assets live? Do they know where I bank? Do they know how to get into those accounts? Do they know how to sign on to anything, my business? Do they know how to get a hold of my clients? Do they know how to properly protect my Facebook page, so that way it doesn't get taken over by fraudsters? Do they have my personal information, date of birth, social security number, things like that, so they can notify credit reporting agencies? All of those kind of digital type things become very, very important to quickly get control over, because there's we live, unfortunately, in a very sick world where people watch the obituaries and they immediately use those individuals for fraud attempts. And so they'll start taking out credit cards in their names and try to sign loans and try to get access to bank accounts and financial statements and things like that. Protect your loved ones, protect yourself. Have a digital step by step. Here's the password to my computer. Here's the user ID to my LastPass, so you can get in and start shutting things down on my behalf. Here's the document that's stored on my computer with a name that doesn't just say passwords. Because if you get hacked, guess what? All of your stuff is now open for grabs. But here's where that document lives. Here's a copy of it. Here's the last time I updated it. Whatever it is, make sure that information is accessible to your loved ones and to those who are going to be responsible for being your personal representatives and or your successor trustees. So those are the 5 things. Again, have your estate plan written. Make sure your beneficiaries are up to date. Have your end of life documents drafted and thought through. Make sure that your funeral and your burial wishes are known and written. And then finally, have a digital legacy that your loved ones can access. Finding a professional who can help you through these is not that difficult to do. You could simply Google estate planner in my area, estate planning attorney in my area. And you can find a lot. The hardest thing is going to be who to pick. Not all that different than a financial advisor, but if you're working with a financial advisor, they can help you find the right professional. Most of your financial professionals network together. So your financial planner or advisor is going to know an estate planning attorney, and they're going to help you do this. Your financial planner and your estate planning attorney should be able to work together for any other estate planning techniques that can be helpful. Sometimes retitling of assets is important. Very, very, very important. If you have a trust written, fund it as intended. Don't leave your trust unfunded because it basically is a waste of money. What I mean by that is if you open and have a trust written, make sure you're home in the right situations. Again, your attorney is going to be able to give you advice on this, but get your home retitled to the trust. Get your non-retirement assets retitled to the trust, your brokerage accounts, things like that. Because if you don't fund your trust, if you don't retitle assets in the name of the trust, it's all going to go to probate. So it defeats the purpose of even having that document in place. So get that done. Make sure your stuff gets funded. Get with a professional who can advise you on how to do this the right way. And if you go to a financial advisor after hearing this and you say, hey, I want to do some estate planning, and they present you with a life insurance policy package, that's not complete estate planning. That's part of a estate planning strategy. Maybe that's a tactic, but that's not what I mean by estate planning, and that's not what I mean by end-of-life planning. Yes, life insurance is important. However, it is not your estate plan. So make sure that you consult with an attorney along the way. And if you have questions about your financial situation or your estate planning needs, as I've said earlier, please send an email to info@lifemoveswealth.com or head over to lifemoveswealth.com and click the schedule button. I'm happy to talk with you. I'm happy to hear more about your concerns. I'm happy to explore what it might look like to have Life Moves Wealth and myself as your financial advisor going forward. And most certainly, we're going to get you into the office and in front of the right financial, not only planning professional. Again, if you don't want to work with me, I can help you find somebody in your area who would be reputable to work with. But either way, we're going to get you in front of the right estate planner and the right estate planning attorney and get all of this done for you. All right. So I know this has been a lot of information to digest. Hopefully you've taken notes, and please do share this episode with people that you care about or somebody who you think really needs to have these things in place. Listen to this with your spouse. Write down the 5 things that you need to do. Listen across those myths again that get busted, and just make sure that you have this done. And don't wait. We never know what kind of time we have to do this. So I just encourage you to get your loved ones taken care of through the steps that we talked about in this episode. Okay, that's it. As always, certainly appreciate you listening. Be sure to drop a comment, hit the like and subscribe button, share the episode, and any questions or ways that we can be helpful, send a note to info@lifemoveswealth.com, and I look forward to talking to you there. Until next time, take care. If you enjoyed this episode, be sure to like, subscribe, and share. Learn more about your financial purpose at lifemoveswealth.com.